All right, guys, what's up? June 8th, we had a good day today. First, this is Doug from Salt Lake. Education purposes only. This is just information. This isn't legal advice. So, we had a good day today. We went down to the bank and we opened up our bank account for our trust. And we made it very clear after speaking to a couple of gentlemen what we were doing, why we were doing it, and if you remember this constructive notice, uh, if you go back a couple of videos. So we put this together because according to public law and the Privacy Act, okay, you are not required to give them a social security number. Now, there's a couple of things I want to touch on. Okay, number one, when you become a secured party, and you declare your trust and you get your EIN number for the trust and you get your security agreement and you do all of the things that I did with securedservicesco.com that I've mentioned several times. Once you have taken certain steps and corrected your status and made it very clear to all parties that there is a difference between a man and a woman, or a man or a woman, and an all caps name, and you have once again corrected your status, you can go in and you can open up a bank account for your trust, and you can provide the bank with certain documents that will help them not to do anything stupid. Okay? So, once again, this constructive notice, okay, I'll let you read this. This basically just says I have the right to privacy. Privacy Act of 74 says it's unlawful for federal, state, local government agencies to deny an individual the right, benefit, or privilege because of such individual's refusal to disclose his social security number. Okay, then there's a couple of case laws, and this is something that you should probably read. Maybe get a hold of me. You can get a copy of this, because when you go to the bank, you open up your bank account in the trust's name, and what you're going to want to do is get an acknowledgement from the bank, that you are the authorized representative. Okay, so you put up the bank's name and stuff here, the date, the account number, the customer, the EIN number, and all that, and you put it's from you, and you are the trustee of the trust, and then you will make it easy for them by providing an email for them. So if anybody wants to get in contact with me, there's your sign right there. And I just wrote a little one-page letter to the bank today, and I put that on June 8th I opened an account at your branch with Bryant for my trust. Brian has always been a pleasure, and he should be considered an asset, right? So you suck up to him a little bit. So I, Douglas Richard Mooney, a man, am the authorized representative of the account holder. Okay? Now you're separating yourself and you're making it very clear that you know that you are the authorized representative and you are not this all capitalized name. Okay? So I am the authorized rep of the account, and I have a security interest that has been perfected and filed with the Secretary of State, seen in my UCC financing statement. Okay? So you're giving them clues right here. Okay? You're using the right language. Security interest. You have perfected, which means you gave them the 30 days. They defaulted, so it's now public record. Okay? The primary objective of this communication with you is to obtain acknowledgement. So I want them to acknowledge that they received this letter, and that I have noticed you and your company, that I have a documented security interest and control of this account as the authorized representative. Okay? So you're making it very clear to them that they have no interest in my property, and neither does anybody else. The Douglas Richard Moomey Trust is the debtor, and Douglas Richard Moomey is the secured party, trustee. And all deposits, accounts, transfers, account numbers, social security number, TIN numbers, property, bank cards, interest, contracts, agreements, and certifications are exempt from levy because I hold a security interest and I have control of all the collateral. Okay, what's the collateral? Well, the collateral is the funds that are in the account. As seen in the security agreement I gave to Bryant, along with the declaration of trust documents I also gave to him to use to open this account. Okay, so when you go in and you get your secure party UCC financing statement and all of your paperwork in order, and you've waited your 30 days, you go to the bank and you open up a bank account for your trust. Okay, because now you are the secure lien holder, okay, of all the collateral, and it's in your security agreement with your trust. Okay, I think I've showed that to you before. It's about 15 pages long, and everything, including your blood, your breath, your DNA, everything you own, everything you used to own, everything you're gonna own, everything, okay, is in the trust. And you have a security interest. That means you're top of the line. You are the boss, okay? So, okay, so trust documents I used to open this account, okay? So let me be very clear. I am not a U.S. citizen or a U.S. person as it's defined in United States Code. I am not in federal jurisdiction or any corporate jurisdiction. I am not a corporation, and I am not required to use a social security number. And see attached constructive notice, right? Which we already went through. Okay, here we are back at the constructive notice. You're being aware, constructive notice, violation of federal law to refuse to open an account, okay, a non-interest bearing account, if the party wanting to open the account does not provide a social security number. To provide your services to a client because their client or potential client does not provide a social security number or taxpayer identification number, okay? You personally and the institution may be held liable for damages, okay? In accordance with Section 1 of Public Law 93-579, also known as the Privacy Act, and Title 5 of the United States Code, also known as Privacy Act, you are being informed that the right to privacy is a personal and fundamental right, okay? Protected by the Constitution of the United States, you may maintain your records only such information about an individual as is relevant and necessary to accomplish the purpose of required by statute or by executive order of the President. Section 7 specifically provides that it shall be unlawful for any federal, state, or local government agency to deny me rights, okay, provided by law because of my refusal to disclose Social Security account number, okay? Which we all know that's not really your number, but the right of privacy is a personal right designed to protect persons from unwanted disclosure of personal information. And enacting Section 7, Congress sought to curtail the expanding use of Social Security numbers by federal and local agencies by doing so to eliminate the threat to individual privacy. Okay, and then there's a couple more in here. 76 Amended Social Security Act, codified 42 U.S.C. 3001 and others, 405, states that there are only 4 instances where Social Security account numbers may be demanded. Okay, that's if you're a taxpayer, to receive public assistance, to obtain a driver's license, and register a motor vehicle. Okay, those are where they can demand it. You can still tell them no, but okay. So then there's that, and then, you know, you sign a date and you send that off to them, okay? So that's one That's our constructive notice that we sent to him, just to tell him, you know, hey, look, I'm not pulling this out of my ass. You know, I'm not making this shit up. It's here, and you're on notice. So let me be very clear, okay? I'm not in your jurisdiction. I'm not a corporation, and I am not required to use, okay? I have the right to privacy. I have the right to be let alone. I have the right to be secure in my person and my property. Please respect my privacy and do not give any information about this account to any third party ever without first getting written consent from me, the trustee. Okay? That's pretty cut and dry, man. This is, you know, I'm trying to operate in private here. So, in the event of default or dishonor by Wells Fargo, shit, I just told you it was Wells Fargo, didn't I? Or its agents, or any third party to remove, lien, or levy any collateral mentioned above in said account, constitutes secured party's authority to foreclose on the collateral in the account before the lien can take effect. All property in the said account is accepted for value, exempt from levy, and is private property of the secured party as authorized representative of the debtor, and is now public record. Please send an acknowledgement to the email above that you have read and understand this communication. Okay? So there you go. So your bank account should now be exempt from levy. Okay? They cannot just take your money and give it to a state rogue bunch of ignorant people that are trying to steal your money for child support. Okay? So, and I'm talking about everybody. State debt collection, you know, office of the whatever, you know, whoever they are. And we're also going to get into how to sign your signature without liability. Now, this comes from Cracking the Code, 3rd edition. We're going to do another video on that. I wanted this one to be kind of quick. The other one's going to be long. We're going to read this, and we're going to show you exactly what these people are doing. Okay? Because, let me show you one more thing. Okay? Here it is here. So, this is the voided check that I got from the bank. They gave me 3 of them just to have a couple of, you know, I'm going to get the debit card, all that stuff. And, you know, in that paperwork, you know, I said that I'm the authorized representative. And this is microprint. And if you can't see the words authorized signature right there, okay? If you can't see the word authorized signature right there on the signature line, okay, at the bottom of the check where you sign for the debtor, okay, you are signing for the account holder. And we'll get into that in the next video, okay? And we'll talk about how to sign your name without liability. Okay, peace.